All right, welcome everybody to Proposition 19 is here. Now what? That is, some people want to use more colorful language to describe it, but I'm sticking with now what. This is kind of the sequel to the program that I did in early January and has some very recent additions of material. So I'm going to talk for about 15 minutes or so, and then I'm going to turn it over to Ray, and he's going to tell you about business entities and LLCs. So first, just a very brief summary of Prop 19. Then a couple of my key takeaways I learned after doing a whole bunch of Prop 19 consultations with people. Then we're going to talk about how to move yourself. This is for the 55 and older crowd, of which I'm in, how to move and keep your Prop 13, because there's some new rules about that. Then we're going to talk about what you can still do to protect your rental and commercial properties from reassessment. And then we'll have time for questions and answers. And for those of you on your phone, you're missing some great cartoons. I put up all new ones for this one. All right, this program will be recorded and posted on YouTube. I am now a YouTube star. I had thousands of views on my last one, so please tell all your friends and family and people who need to have trouble getting to sleep at night to watch this video. The basic disclaimer again is don't try this at home. This is very complicated and it's kind of a family by family analysis. So you kind of need a consult and then we can tell you what's best for you. But I've got some great general information that you will enjoy. I'm Joel Harris. I'm a state board certified specialist in estate planning, trust and probate law. I also have my master's in business. I specialize in writing and repairing estate plans and doing estate administration. My beautiful co-speaker is Rey Gervacio. I've worked with Ray for almost 26 years. Ray is also a certified specialist and he has his multiple masters in tax law. So Ray is an extremely useful fellow to have on these programs.
Could you get a pickle?
I heard something about passing a pickle. We'll have to wait until after the program for that. So here's where we are today. A man in the morgue, cause of death, sudden heart attack, brought on by opening his property tax bill. So now that Prop 19 is the law of the land, where do we go from here? Well, we still have the good news. If you're 55 or older or disabled, you can move 3 times anywhere in the state and keep your Prop 13 tax basis. So the good news is the same. The bad news is the same. Your heirs lose Prop 13 when you die, with the exception of the first $1 million in value on your home. So it's the rule is assessed value plus $1 million if they move in. I'm going to talk to you more about how that works. Any other properties or any properties worth more than assessed value plus $1 million will be reassessed when you die. And I'm going to talk about that more later. So I just kind of want to go through the basics quickly. So I did a lot of consultations with new clients and old clients regarding Prop 19. And after a few weeks, I was not able to help new clients anymore. I was only able to help my existing clients. And the reason is about 95% of the estate plans I reviewed for new clients were so badly messed up, I had to fix them before we could proceed. And some were unfixable. So I had situations where I had dead or incapacitated people on deeds, and there just wasn't time to fix those. I had estate plans that had dead people or completely uncooperative people on the estate plan, and they would not allow us to fix the plan. So folks, we've got to do the basics, of course, before we do the advanced planning. So it's extremely important, especially when someone dies, that you call up your estate planning attorney and say, now what do I do? And fix things, take the deceased people off of the deed. So if anything comes up and you want to sell or refinance, or if you die or for your heirs, all of these things require you to have your estate plan in good order. So because of bad estate planning, We have people that were not able to do their Prop 19 planning. So some clarification that has come out from the Board of Equalization in the last couple of weeks. So number one, when you die, only one child has to move into your house. They don't all have to move in. So only one is required. They have to move in within 1 year of the date of the parent's death and file a claim for a homeowner's exemption with that county also within 1 year of the death. If that is not done, then we lose the $1 million exemption as well. Now, a lot of folks think, well, 1 year is plenty of time, but you'd be amazed how many people think, oh, well, there's a living trust and I'm in the property. I don't need to do anything. The current the previous rule of 3 years, I had many, many families blow the 3-year rule. So your heirs have to be on top of this. There are taxes that have to be filed and forms that have to be filed when you die. Another piece of clarification is that you don't have to own 100% of the home. The portion you own will be exempt. So this is made for example, people who own a small apartment building and the parents live in one unit. Well, that one unit then will get an exemption. Or if the kids own half of the parent's property, the parent's half is entitled to the exemption. The next rule is the child is not allowed to leave the house. So people are saying, okay, ever? Is this COVID for life? No, they are allowed to have a period of temporary absence. So what happened is folks from the armed forces were asking the Board of Equalization, well, what if we go out on deployment? So if you go on deployment or if you go on vacation, that's not a problem, but you can't move to another home. A family farm does not need to be a primary residence to get the $1 million exemption. There were material out in November and December that said it had to have a primary residence on it. It does not. The date of transfer or the date of death preserves Prop 13, but the proper documents have to be filed. So if your parent died before February 16th, it all goes under the old rules. Otherwise, you had to do your gifting and everything before the 16th of February. So, but the old rule applies. There's no emergency if somebody died in the last couple of months to get this in. You have 3 years from the date of death. The other new thing that we learned is the $1 million will also apply to gifts. So if you gift a primary residence to your kids, you can also keep the Prop 13 if the value is assessed value plus $1 million or less. So that applies to inheritances and gifts. All right, here comes my favorite page. I have a lot to say about this, and this is brand new and it's driving me nuts. My wife will tell you my rant about it. So as we know, it was quite a scramble to get all of our deeds recorded by the deadline of 2/15, which was a holiday, and 2/12 was a holiday. The title companies were so overwhelmed that I actually flew to LA on February 1st and delivered 36 deeds to my electronic title companies so they could all be recorded on time. This was done because some counties like Alameda said that they would not accept any transfers that weren't recorded by the deadline. The state bar held a webinar with the Board of Equalization a couple of weeks ago, and about 1,000 lawyers screamed at them and said, look, we have to have a clear rule that everybody is following. So the Board of Equalization, and they were on board with on the meeting, they officially said on the 16th of February that the deeds signed by the 15th on time for the law don't need to be recorded on time to be valid. Well, God, you know what? Why couldn't they have told us a couple of weeks earlier? They made the ruling the day after the deadline. But the good news is that if there's any kind of recording issue, that won't be a problem. We can record it. There's no hurry to record those now. The real deadline was just to sign your gift deeds or your irrevocable trusts. So they are legal once they are signed. The latest piece of information for you is maybe a thing of beauty. This is California Senate Bill 668, introduced 10 days ago, less than 10 days ago, that would change the effective date of Prop 19 by 2 years and would give us 2 more years to do all the planning. So that would be great. I'm not 100% sure if that's legal or not. But if that passes and we get the 2 years, then that will give us a chance to really do some careful and planning without me having to fly to LA and bribe the title company with boxes of donuts. So keep an eye on that. And if it passes, I will send out a newsletter all about it. If you don't get my free newsletters, please shoot me an email so I can sign you up. Or you can put your email address in the chat box. So these are the developments in the last 2 weeks, very important. So I've had a lot of questions about this. I had these on the initial program. How do we move and keep our Prop 13? So you have 2 years for purchase or the completion of new construction has to be done within 2 years of selling your old property. The old property has to be sold / reassessed for you to qualify. If the new property costs more than the old property, the reassessment will just be on the difference. But what's important here, kind of the big update, is this is a two-step transaction, and you don't have to do both steps by April 1st to take the advantage of moving. So if you sold your home before April 1st, but you move after, you get it, you win, as long as you sold it within 2 years of April 1st. But if you sold your house and bought the new one before April 1st, then the old law applies and Prop 19 won't help you. So clarification on this from the Board of Equalization. If, quote unquote, if the replacement residence is purchased or newly constructed on or after April 1st, the primary residence may be sold either 2 years prior or after the purchase to qualify. So keep that in mind if you're planning to buy or sell. And the good news is you, husband and wife, can do this 3 times each. It's per person. So now married couples can move 6 times. Or, you know, in Utah, if this applied, I guess they could move 18 times. So I don't think anyone's going to hit the limit on that. The forms for all of Prop 19 for homeowners exemption and claims and so forth are all now on the Board of Equalization website. They went live on February the 5th. So next topic, how to protect your Prop 13 for rental and commercial property. First comment is, and I'm going to be turning this over to Ray now, but the first comment is call your legislature and tell them to vote yes on the 2-year delay. Because right now it is too late to make gifts or use irrevocable trusts. The best and perhaps last remaining option is using a business entity like an LLC on the mirror proportional interest rule to protect yourselves and your family from reassessment. And with that, I'm going to turn it over to the expert in this topic, Dr. Gervacio. Ray, take it over.
Thank you, Joel. Let me go ahead and switch over here. Hopefully I can get this done right. Are you seeing my screen?
We are, but it's still, you can see the little screens on the left too. So start the slideshow.
Right, okay. So let me go ahead and this is mine. Sorry about that, guys. Let me get this up and running. And I'm gonna start where you left off, which is right here. All right, how's that?
Perfect.
Perfect, okay. So one of the options would be to use an entity, such as an LLC. In other words, how do we get property to another without getting reassessed? certainly one way would be to use an entity. And when I say entity, I mean a corporation, a limited family partnership. LLC is another entity. And we're going to use an entity today for this purpose of this talk. And under the right circumstances, it can actually work, okay? So I'm going to first start by talking about how property tax is calculated so that we're all on the same page. In this example, I'm going to use John as our person here, who's our star. John will be purchasing real property in 2000, and he's going to purchase it for $400,000. And how is property tax going to be calculated in this situation? Well, in our example here, the purchase price is really the base that we're going to use to calculate property tax. I call this the beginning assessed value. So we take the $400,000, we multiply it by 1.25%, and we come up with $5,000 a year. Now I use 1.25% because California really is 1%, but what happens is because many other counties have different assessments, it often comes out to about an average of 1.25%, okay? So moving forward, after he buys this property, the property tax is $5,000 a year. Now, we also know that these taxes will increase every year because the value of the property will increase every year. And so this is how this works. As property values go up, so will the property taxes. And the taxes, again, will be based on the assessed value. Now, in our example, we're using a 20-year term from 2000 when he buys it to 2020, for example. Over a 20-year period, the assessed value will increase at a rate of 2% a year. So my calculation shows the $400,000 assessed value increased to $600,000 in 2020. So the property taxes in 2020 will be $7,500 every year. And the calculation is the same way. We take the assessed value, multiply that by 1.25%. Now, another thing I want to talk about real quickly is the issue of transfers or change of ownership, because the rule is, this is a general rule, any transfers or change of ownership in real property will always be reassessed unless there is some kind of exemption, okay? So in this particular example, let's say that John were to pass away, that is considered a transfer. So a transfer is either a sale, a gift, or a death, where someone inherits something. So how property taxes are reassessed is we will take the value of the property at the time of the transfer, and let's pretend in our example that the value of this property in 2020 increased from the original $400,000 to $2 million. And so we take that $2 million value at the date of transfer and we multiply that by that 1.25%. Okay, and in this particular case, if this property is reassessed upon John's passing, then the new property taxes will be $25,000 per year. That's a difference of about $17,500 a year. Okay, so what about how do we avoid reassessment using this LLC? In other words, how does an LLC potentially avoid reassessment? I'm going to talk to you about two different concepts. I'm going to talk to you about the LLC as an original owner and the LLC as a non-original owner. Now, these are not terms used in the statute or the code, but I'm using it to kind of help demonstrate so it's easier to understand. Okay, so I'm going to start with an LLC as an original owner. This is a scenario where the LLC acquires or purchases the property. And at the time of this acquisition, the property was actually reassessed, okay? Now, if the property is acquired by the LLC directly, the property was reassessed, the LLC is considered an original owner. So if the LLC is the original owner, what we do is we look to the revenue and tax code that tells us how the rule with regards to reassessment on this such type of situation. The rule under 64C says if the ownership interest in the LLC is transferred, so long as each transferee does not receive more than 50% of the LLC interest, then there's no reassessment. Okay, so I'm going to show you an example to kind of explain the rule. Let's say that in 2000, John creates his LLC. A year later, John's LLC purchases property one, and he purchases it, the LLC purchases this property for $400,000. This particular transfer or this particular purchase by the LLC, the property was reassessed. Okay, that's just normal when you buy something. Now, in this example, because John's LLC purchased the property directly, the LLC is considered an original owner, and we're using the Revenue and Tax Code 64C as the rule that will govern this particular situation, okay? Now, how is the LLC going to be taxed for property tax purposes? It is the same way as if the person purchased it, okay? So $400,000 purchase price. Joel, you want to mute, Joel? $400,000 purchase price, and the property taxes on this purchase price would be $5,000, just like with John. But the LLC is the one paying this over a 20-year period. The property tax again will increase to $7,500. The same calculation as if the person had purchased it. Now, in this example, however, let's say John passes away in 2021. Okay, 2021 he dies, and his LLC interest transfers 50% to his son John Jr. and 50% to his daughter Jane. Will this situation result in a reassessment? And the answer is no. No reassessment when John dies and his LLC interest goes to his kids. The LLC, remember, owns the property. So the rule again is whenever there's an original owner where the LLC is the original owner, it says so long as each transferee does not receive more than 50% of the interest, then there is no reassessment. Certainly, John's son, John Jr., received 50%. The daughter received 50%. That is not more than 50%. So no reassessment in this situation. Okay. Now, if there was a reassessment, what we're looking at is the same type of analysis. If there is a transfer, remember the reassessment will be based on the value of the property at the time of transfer, and we do the multiplication of $2 million. Fair market value times that 1.25%. Again, if this property was reassessed, the kids through the LLC would be paying $25,000 a year. But because in this scenario, there was no reassessment because the rule allowed the John's estate to transfer the LLC without being reassessed, then the LLC and the kids will continue paying that $7,500 a year in property taxes. Okay? So what about what happens in the future? The kids own 50-50 of this LLC interest. Let's say John Jr. transfers his 50% LLC interest to his two kids. So each of his kids receive 25% each. Will this transaction result in the property getting reassessed? And the answer is no. And the same way, if the daughter transfers her 50% interest, let's say to her son, her one son, there will not be a reassessment. And the reason why? The rule. So long as each transferee does not receive more than 50%, there will not be a reassessment. Okay? So as you can see, using the LLC as an original owner, it is very possible for this property to be passed down for generations without ever being reassessed. So long as we follow the rules of never giving more than 50%, especially if you have more than one child, there's already the rule, right? You can pass on less than 50% in that situation. But the question for most of us is, what if the LLC did not purchase that property? In other words, the LLC is not an original owner. What can we do? Well, if an owner purchases property in his name first, then later transfers the property into an LLC, this results in the LLC to be not an original owner. In other words, the LLC is not an original owner of that property. And if that's the case, we fall under a different rule under the Revenue and Tax Code. This rule is under 64D, which says if the owner of the LLC transfers 51% or more of the LLC interest, there will be a reassessment. Okay, so let's take a look at an example to see how this works. Let's say in 2000, same scenario, John purchases the property one in his name. He bought it for $400,000. A year later, John then creates an LLC and transfers his LLC, transfers his 100% interest in the property to his LLC. Now, in return for this transfer, John then receives a 100% interest in the LLC. Now, the LLC owns no other assets except for this property. Okay, so that means in this scenario, the question is, will this transfer from John to his LLC of this property be reassessed? right? Will this cause a reassessment? Now, let's go back to the general rule regarding transfers. Whenever there is a transfer, there will be a reassessment unless there is an exemption. Now, entities are not exempt from this. So the rule here for entities is transfers to an entity will be subject to reassessment unless it meets what's called the proportional interest rule, okay? The rule basically says, this proportional interest rule, it says if the transferor of the property to the entity and the transferee, the person receiving the LLC interest, retain the same proportional interest, no reassessment. So let's look at the rule and how it applies. Remember in our example, John in 2001 transfers his 100% interest in the property to his LLC. And in return, he receives a 100% interest in the LLC. So the LLC owns the property now. John owns 100% interest in the LLC. In this example, there is no reassessment under the proportional interest rule because he meets that test, okay? And because the LLC did not originally purchase this property, we know that the LLC is not that original owner, right? So in our example, in 2021, John passes away under this example. He dies. And his LLC interest is transferred to his two kids, 50% to his son, John Jr., 50% to his daughter, Jane. Will this transfer be reassessed? Yes, this will be a reassessable event because remember the rule. If the owner of the LLC transfers 51% or more of the LLC interest, there will be a reassessment. Now, in this case, what happens? John's 51% transfers of his 100% interest went 50% to his son, 50% to his daughter. That is greater than 51%. Therefore, that's why this transaction is being reassessed based on the non-original owner. LLC is a non-original owner. All right, let's back up for a second. What if instead John, instead of dying, okay, let's say he just instead transfers just 50% of the LLC to his son, John Jr., and keeps the other 50% for himself. Will this transaction result in a reassessment? Again, it does not. Remember the rule? If the owner of the LLC transfers 51% or more, in this case, he's only transferring 50% of his LLC interest to his son. Therefore, it's less than 51%. But let's say that John gives away 1% sometime in the future to his daughter. That will trigger that reassessment, okay? Or when John dies, his 50% interest will now be transferred to his kids, for example. That will result in a reassessment because more than 51% was transferred from John at that point, okay? The first 50%, no issue. Anything more than that in the future, like when he dies, that will be reassessed. So you can see when using an LLC, the best option really is to have the LLC be an original owner. But what if it's already too late? You already own the property, okay? How can we use an LLC so the property is not reassessed when you, the parent, dies? Well, let's take a look at a scenario, okay? As an example, in 2000, John purchased that property in his name for $400,000, okay? Then we do some planning. In 2021, John creates an LLC and transfers his 100% interest in his property to his LLC. Now, John in return receives a 100% interest in that LLC, so we know no reassessment in that transaction, right? Under the proportional interest rule. So there's no change in property taxes in this particular transaction. A year later, John does the following. John transfers 50% of the LLC interest to his two children, John Jr. and Jane, and John keeps the 50% for himself, okay? This transaction is not reassessed because remember the rule? If the owner of the LLC transfers 51% or more of the LLC in a non-original, LLC is a non-original owner scenario, no reassessment if it's less than 51%. He only transferred 50%, therefore no reassessment when he gives the LLC interest to his children. Then another year passes by and John does the following. John terminates the LLC. The LLC then transfers John's 50% interest in the LLC the property back to John, and the other 50% back to John Jr. and Jane, all as tenants in common. So now John, Jane, and John Jr. are now tenants in common. They each own, John owns 50%, and John Jr. and Jane owns 50% tenants in common. The question is this transaction reassessed? Well, the general rule, or the easy answer is it should not be reassessed, because remember, John is receiving 50% of the property for his 50% proportional share in the LLC. Remember the proportional interest rule? And the kids are receiving 50% of the property for their 50% proportional share in the LLC. However, I can tell you right now, the assessor's offices are now scrutinizing these types of transactions. They may not allow it. In other words, if they find that this transaction was done purely to avoid tax, they may not allow it. Okay, now under Prop 13, when the Prop 13 was around, it was easy because we can use a parent-child exclusion and they weren't even looking at these transactions. But now that Prop 13 is gone, they're scrutinizing these. Now, again, if this is done correctly, you need to go to the proper lawyers to be able to do this, people who knows what they're doing. Don't try to do an LLC by yourself and try to emulate this type of a transaction. Again, if you don't do it right, the entire thing will be reassessed, okay? Now, if done correctly, and it's allowed, certainly no reassessment, and John will own 50% of the property, the kids will own 50% of the other half of the property taxes will not be increased. So, since there's no reassessment, again, the kids and John will own the properties and they will continue paying that $7,500 per year in property taxes. Then we wait yet another year. At this point, John and the kids will set up a new LLC and they will transfer their interest in the real property to the LLC for a proportional LLC interest, okay? No reassessment, remember, if you're transferring, if you're meeting that proportional interest rule. But by John putting his 50% interest in the property, in the LLC, and the kids putting their 50% interest in the property into that LLC, they are now going to be considered original co-owners of the LLC. So when that happens, if they are original co-owners, that means John owns 50% as original co-owner, kids own 50% as original co-owners. Now in this example, let's say John dies, his 50% interest in the LLC will go to his kids. No reassessment. Remember the rule. If the owner of the LLC transfers 51% or more of the LLC interest, there's a reassessment. He's only transferring upon his death only 50% in this scenario, okay? So there is no reassessment. And certainly when John dies, the parent dies, no reassessment, and the kids can continue to pay the lower property taxes in this scenario. So as you can see, by using an LLC, you can get the property to another without reassessment. Certainly the best way, the gold standard, would be where the LLC is the original owner, right? But if it's too late, well, you can use what we call a multi-year transfer strategy. Well, we create original co-owners using the LLC, and at least at a very minimum, we can avoid that reassessment upon the death of the parents, okay? So one other thing I want to talk about very briefly is benefits of the LLC. Certainly an LLC is a very dynamic entity. It adds asset protection. So if you own, say, an asset or a business in an LLC and there's a problem resulting from the use of that property or that business, well, any lawsuits will be limited to what's inside that LLC. It won't go outside and you don't have unlimited liability. That's why we set up typically LLCs and corporations. Also, Prop 19, LLCs and entities are not affected by Prop 19. And taxation options. LLC is a great tax option because you can be taxed as a corporation, you can be taxed as a partnership. We will work together with your CPA when we're doing tax planning before creating these entities, okay? So having said that, I'm gonna just turn this over to Joel now to kind of wrap it up because I know we don't have that much time. So Joel?
Time to unmute myself. Oh, look, it's like the Brady Bunch right now.
You're good. You're unmuted.
So I've got a question or two for you, Ray, and then I'm going to repeat a couple questions in the box.
All right.
So Ray, I've came over the situation in the last couple of months of families where we have a property that already has 3 or 4 owners into it. So if we turn around and put that property in an LLC with the same 3 or 4 owners, is there anything else we have to do other than let our kids inherit our partial interests?
Okay, we just have to be very careful. Remember, if the LLC is not the original owner, okay, we're under the 64D rule, which means if any of the owners, any of their interests exceed 51%, that's transferring, it's going to be reassessed. Okay, so the other way, 64C is the best way because it is what is being received, the recipient. If the recipient receives less than 50%, for example, then, or 50% or less, then what happens is there's no control by one individual. Therefore, it works for the first under 64C, but it doesn't work under 64D.
So if we have 3 or more owners already, the LLC should be pretty simple.
It may be, again, it depends, right? It depends on the situation. We'll have to analyze that.
Now, I had another question on the chat room about stepped up basis with LLCs. And the stepped up basis with LLCs, folks, works the same way. Whatever is inherited still gets a stepped up basis, whether it's inherited from your living trust or your LLC. It's what's gifted during your lifetime that does not get a step up in basis. So your LLC assets will still get a stepped up basis when you die, but now your kids won't get reassessed. So that's a nice combination. I want to tie 2 things together from the beginning of the program. As Ray was mentioning about original owners and about scrutinizing by the counties, if we do get a 2-year extension on Prop 19, folks, now is the time to do the LLC. We'll wait a couple months and let normal things apply, and then the counties probably won't be worried about something that you're pre-planning for years down the road. All right, Ray, I'm going to read you some questions now. Here's a good one. If you only have 1 child, can you set up an LLC and give 50% to the child on your death and the other 50% to an entity like an irrevocable trust to avoid reassessment?
Well, who's the beneficiary? Remember, with trust, the assessors will always look through, if it's an irrevocable, it'll always look through the trust and look at who's the beneficiary.
So
and
the
beneficiary will be
child, then it won't work. But if the beneficiary is the grandchild or Carol Shuey, would it work?
Yes.
Perfect. Carol, we'll sign you up.
And remember, Joe, we have to first distinguish, is it under the original owner as an LLC or the non-original owner as an LLC? That's why we have to meet with these clients and really make a determination. We can't just, this is not legal advice. I mean, we don't have enough facts to be able to say this will actually work or not.
Yeah, it's very individually planned. All right, here's a question for you, Ray. I plan to purchase a house in a few months. How do I create an LLC?
Well, if you have a lawyer, you can ask your lawyer to help you set up that LLC. And make sure you structure it properly so that, again, it does not violate any of the revenue and tax code rules, right? We want to make sure it's done properly. That's really the best solution. Go to an attorney. Don't try to do this yourself. Don't try to do this online because you could make a mistake.
Ray, what if this is a primary residence and they want to put it into an LLC?
Well, here's the general rule, okay? There's really no legitimate business purpose for putting your primary residence in an LLC. But at the same time, I have to tell you, the governor of the state of California has his home in an LLC, okay? So, I mean, this is a tricky scenario with dealing with real properties and LLCs, but this is something that as we're going through this, you know, the rules now that we're learning through the BOE, the Board of Equalization. So some of these things may come up later on. But again, I would not recommend putting the primary home in an LLC, but certainly technically you can do it, but there's going to be a lot of things you can lose with regards to benefits if you have your primary home. Number one, you don't have your homeowner's exemption anymore. Number two, if you do decide to sell it in the future, you have lost your Section 121 exclusion for the capital gains, right? If you're married, it's 500,000 exclusion, 250 if you're single. If it's in an LLC, you don't have that. You don't have those benefits. So it depends. That's why I said we have to look at your situation individually, and then you will analyze what's most important, property tax or all the other taxes.
We have a question. What is the definition of severely disabled? I don't have the answer to that. I've been looking on the Board of Equalization website and it's not popping up, but it's on there somewhere. So you're going to need to go to the California State Board of Equalization. Otherwise, my definition would be whoever's applying, whatever your disability is, it's really none of their darn business. So you should qualify, but to look for a more exact definition, you'll need to research on the Board of Equalization. I would assume if you're getting disability that would qualify, but this hasn't even gone into effect yet. This goes into effect April 1st. So hopefully there's a definition on there for you. Next question for you, Ray, is what about the revenue of the LLC? If we wanted to remain with the parent during the lifetime, but the parent only owns half, so who gets the income?
The owner. Who's the owner of the LLC?
Yep, if the parent owns half and the kids own half, then I would think the owners would get the income. And it would go on the owner's income tax rate.
Correct. So depending on how that LLC is taxed, remember, as I mentioned, the LLC can be taxed as a corporation. It can be taxed as a partnership. So that's why we talk with your CPA to see what's the best way to structure this. So yeah, we don't try to wear two hats or three hats. We wear one hat. We're the lawyers, even though I understand taxation. Okay, I have a master's in tax. I'm not going to wear two hats because there's checks and balances there.
All right, any other questions? You can either unmute yourself and shout them out or type them in. Because if you're on your phone, typing is hard. So we are going to be doing this program again Thursday night at 6 o'clock. So feel free to come back or invite your friends and family. And we're also going to post this on YouTube. I'm hoping for thousands of hits again. Make sure you get my newsletter so I can give you an update on the new Senate bill that might give us 2 more years to do this planning for you. That would be huge. They also made a few other extremely minor corrections that nobody will care about. So if you don't have a gender, they are going to fix that for you. I'm sure you were all worried about that. Ray, we have another slide or two at the end. Can we put those back on, or can I put them?
Yeah, you can put them on. You can put them on.
Yeah, I've got a great couple of cartoons here. I want to share with everybody. I look really hard for these cartoons. So this was where we were supposed to be right now, Q&A with comic relief. And one of them isn't even new. I think that's pretty funny. So if you're not watching, one is a kid dressed up as a property tax bill for Halloween, and the woman at the door passed out, and the other kid dressed as a witch says, "I told you your costume was too scary." And then here's our contact information. Take a picture, jot it down, carve it on stone, treasure this forever. Ray and I will be taking consultations for doing LLCs. There is a consultation fee, but if you do an LLC, that fee is waived and it becomes a free consultation. So the idea today was to give you all the basic information so you can decide if this is something you wanted to pursue for the property you don't live in. It's best for non-residential property. We will, of course, need a current deed and tax bill to any property you want to put into an LLC, and we'll have an online worksheet we'll send you to that's pretty straightforward to fill out a few things that we would need to see before we talked about that. And there is no deadline on doing these LLCs unless you want to make the original owner. So if you're planning to buy a property soon, you should jump on this right away. Otherwise, we can talk in March, April, May, and get your business entity going. Ray, my chat room is gone. Let me see. Oh, here we go. My chat has disappeared. I can only see everybody's beautiful faces.
Ah, okay, let's see.
I have a question.
Sure.
I was wondering, me and my husband, we have 3 properties and we have 1 child, she's 5. But we're hoping to maybe acquire some more over the years. And I was just wondering, we've been funding them with mortgages. Is it so that the lenders are pretty reluctant to have an LLC as a holder of the deed, or is that going to be a problem, do you think?
Actually, it's a business. So the lenders are more likely to deal with a business, especially if there's cash flow, than a trust. So yeah, the issue we had with dealing with specifically with trust in the past several months was, yeah, if you have a trust, it's more difficult to get a loan, to get refinanced. But if you're dealing with a business, an entity, a corporation, LLC, it's a lot easier.
So it's preferable to use an LLC that is already active, that is already having some sort of business.
Right.
Yeah.
Right. Especially if there's cash flow, especially if there's equity. Yeah, it's a lot easier. Plus,
you would get government bailout money if you had an LLC. So
right.
The state and county grants and the government, the 1% SBA loans, the free PPP money, if you had an LLC, you could have applied for that.
Right.
And that may happen again, you know, the next rounds of COVID. Hopefully most folks here have been shot already. I got shot and it still hurts, but I'm very happy I got shot.
I'm getting mine today, Joel.
All right.
Per your recommendations.
So here's one thing that happened, folks, during all this Prop 19 craziness, is I had people's kids call me up and they wanted to transfer the properties, but mom and or dad were in a nursing home and we couldn't get in to get anything signed. So if we get extended, I've got a family. As soon as I get my second shot, I can go into the nursing home and get dad to sign the paperwork, and we're going to do irrevocable trust and get that house out of his name. It's worth millions of dollars. But otherwise, we can't do it. I had someone else in the ICU. She ended up dying. She was there for a month, only 50 years old. We couldn't get her estate plan done because they wouldn't let me in. I want to go in at this point, because there's where all the sick people are. But once I've got my shots, I can help out with that. All right, any other questions? You got 2 free lawyers. We're like $1,000 an hour or more combined.
I have one last question. I heard some talk about that some people think that Prop 19 might be repealed. Is that the feeling, the general feeling you've been getting also? Or? So
I'm going to address this, Ray, because, well, number one, they can't repeal it. It has to be voted on. So we would need a new amendment, and that'd be great. And I have been checking on this, and nothing is been filed so far. So all we can do is, you know, plan for the law, just like the estate tax. I can't tell you how many times the estate tax has changed since I started practicing, when it was $600,000. It goes up and occasionally goes down, and it's going to go down again. It's almost guaranteed it's going to drop to either 5 million plus inflation or 3.5 million. So we just have to pay attention to things. But there is that Senate bill on the floor to give us 2 extra years on Prop 19. And it's what I was reading about. It said it only requires a majority to pass that. So hopefully that'll give us 2 more years. And that also gives us 2 more years to have the Jarvis Gann help put a proposition on the ballot to eliminate Prop 19 altogether. I think if people understood Prop 19, it never would have passed in the first place.
Yeah.
Good question. This is a question the lawyers asked at that state bar seminar, but not much we can do about it.
Joel, I have a question. How soon will you have this up on YouTube? My wife just missed and she's just gotten back home.
Well, I'm probably gonna wait until after Thursday's show so my YouTube guy can decide which one I'm better looking in, and do the editing, and then he'll post it. So I would guess by early next week, if not sooner, because I want to keep my YouTube star rising.
Thank you.
Got a question.
Yes, sir.
Joel, so in the LLC, it can only be transferred to children, is that right? Or to anyone else,
To anyone.
or 50%. So I
Right.
can do it to my nephew.
Right. So
Okay.
here's the nice thing. Let's say you did the LLC under the first scenario where the LLC is the original owner. Well, you can transfer it to even someone who is buying the property. You don't have to die to transfer it. And that's one of the benefits you can give to the buyer. Is like, look, you can keep the property taxes the same, what I'm paying now, if you do it properly. Okay. But if we fall under the second scenario, again, you can only transfer up to, remember, less than 51%, but it doesn't have to be your children. It could be anyone in the world.
All right. Good. Good to know. Thank you.
No problem.
Yeah, this is a pre-Prop 19 planning strategy and gives us something fun to talk about afterwards. There's somewhere to go. There's so many benefits to having an LLC.
But remember, okay, guys, when you have an LLC, it is a business, okay? And as such, in California, there is an $800 right to do business as an LLC or an entity. So you have to also factor that in. Every year, you got to pay that. Every year, you have to make sure you file the proper tax return, even if it's just a reporting tax return that, and so there's additional fees and costs associated with operating an LLC. You can't just treat it like your own personal bank.
True enough, but it's also like paying for insurance, Ray, because of the liability protection, and your expenses become tax deductible. And other expenses you may have that weren't tax deductible before now may become tax deductible. So that's a great conversation to have with your CPA. So I'm doing everything we've talked about in the last seminars and the current seminars, I'm doing for my family. All right. So again, thank you all for joining us. We're here if you'd like a consultation. And then again, we'll be doing this again Thursday night. So Linda, your son can join us on Thursday night. It's nice to see you. Haven't seen many people in a year, and those have all been masked like this. So with the vaccines getting out and the new one-shot vaccine approved, by the summer, I think we'll be able to, go out and look pretty again, and life will be a little bit more normal. We just all need to be much more careful than we used to be. So with that note, it's a pleasure, everybody. Thank you so much for joining us. Thank you, Ray. We appreciate your information and expertise very much. Take care, everyone. Have a great afternoon.
Bye, everyone.